Hello everyone, Andrew Bethel with the Bethel Law Corporation, and we are an estate planning law firm located in California. Being an estate planning law firm, one of our big practice areas is navigating the probate process. Now, our office does typically counsel our clients that we think they should avoid a formal probate process through the proper funding of a living trust. Unfortunately, sometimes life just does not work out that way, and an estate does end up having to pass through probate. So if you are a part of or involved in an estate that does need to pass through probate, there are some things you need to look out for, some disadvantages or hiccups you might experience through that process, and those are things that you should be aware of going into that. Now, before we get into those in particular, just know that this is a companion piece to our probate overview video that has already been published on this channel. And additionally, we have another video discussing the advantages of a probate that one might keep in mind going into it. Now, the first disadvantage or hurdle you should be aware of is the high cost of going through probate when compared to private planning. So in the probate world, you are dealing with a probate court. Since you are dealing with a court, now you have to worry about court filing fees. Right off the bat, before we can even get anything through the door, there's an upfront fee of about $465, and that will adjust over time. Typically, it's only gone up over time. So again, that's $465 just to get your foot in the door. On top of that, there are other fees associated with having an estate go through probate, such as a probate referee fee in order to evaluate the assets, a notice of publication fee where a notice of death needs to be published. There's random court filing fees where you need to get specific copies of documents and you do have to purchase those. And in California, we also have a fee for closing the estate. So once everything is done, you have to pay another fee to the court just to close the matter out. Now that's kind of the miscellaneous fees you can expect along the way throughout the process, sometimes around $1,500 or so. But that's just the beginning, because your attorney is also entitled to a fee, and that fee is set by the probate code. So there is a formula that is used in order to determine what the attorney's fee would be, and it comes out to 4% for the first $100,000, 3% for the next $100,000, 2% on the next $800,000, and 1% for the next $9 million. So as an example of how that will look like when it plays out is, let's say you have an estate passing through probate that is worth in total $350,000. The attorney's fee in that case is going to be $10,000. Again, that's set by the probate code. There's no way to adjust that figure. It's set by a formula. So that's $10,000 on top of the $1,500 or so in miscellaneous fees just to get the process going. On top of that, the executor or the manager of that estate, the person the court appoints to take care of all the assets, they're entitled to the same fee the attorney gets. So in that instance, the executor can get $10,000, the attorney gets $10,000, and there's about $1,500 of fees up front. So now, just to get an estate through probate, we're about $20,000 in compensation and $1,500 in fees. Additionally, on top of all that, we do have to be worried about any creditor claims that are going to crop up and stake claims on the estate. With that, now we have all these parties entitled to portions of that estate, and they're going to whittle down what will ultimately go down to the beneficiaries. Contrast that with the funding of a revocable living trust, and now for a smaller out-of-pocket fee by, let's say, me at my level, I can ensure that my estate does not have to go through probate. I've taken care of all the assets and putting them in the trust, and now my beneficiaries can receive those assets right from the trust, and there's not all these upfront filing fees or set formula fees to go to the attorney and executor. It's all done and done while I'm still alive. The next thing you need to be worried about is the timeline for a probate case. So in a perfect world, a typical probate case here in California takes about 9 months or so to wrap up from start to finish, from opening the case to closing out the probate and distributing the assets to the beneficiaries. Unfortunately, we don't quite live in a perfect world where we're going to work on these consistent timelines all the time. A big factor we need to worry about is the court's calendar. So courts in California have to run their calendars, and California just being a populous state means that there are a lot of people going through the process. That means that courts often have very large calendars. They have a big backlog of cases that they need to work through, and that means hearing dates are going to be very spread out. So there is already a required waiting period in a probate case of at least 4 months where that probate case has to be open to allow creditors to crawl out of the woodwork and make their claims. That it's almost invariably to where we're never butting up against that timeline of trying to close a matter, but we can't because it has to remain open for 4 months. Almost every single time we're going way past that timeline, and it's not even through any fault of the attorney's office or the executors or any beneficiaries or anything. It's just working with the court's calendar. Additionally, if there are any problems during the administration, such as a beneficiary or perceived beneficiary challenging the will or the process, that's going to instantly cause a greater delay in the entire process. Now, they're going to stake their claim or make their complaint during a hearing, and of course the problem is not going to be solved right there and then, that day. So the court is going to issue a continuance, and now all of a sudden we're dealing with the problem in 3 months down the line because that's just the earliest hearing we could get. So a probate case in California extends often longer than that usual 9-month period in a typical no problem probate case. It's not uncommon we see cases go closer to 12 months or even more, especially in busier counties such as Los Angeles County. So contrast that with private planning through, for instance, a living trust. Now we don't have to worry about other parties' timelines. We're just working on getting assets taken care of, and we can distribute them without having to go to the court before we do anything and ask, Mother, may I do X, Y, or Z? The next hurdle or disadvantage you should be aware of is that because we are in court, these are public proceedings, which means the public can come to these hearings, although typically it's only those who have an interest in the proceedings that show up. Those proceedings are held in the court though. Additionally, the documents that are filed in court also become part of the record, meaning they are part of the public record, and that includes, if there's a will, what that will says, as in who I pick as the beneficiaries of my estate in my will. That's now published in that public record, and somebody can come in and inspect that. Now, my wishes aren't private, they're part of the public record. So probate cases, just due to the nature of them being in the court system, they do have greater public scrutiny on them, but that does mean that there is a public eye on everything that is going on, rather than kind of handling things privately within the family that you would typically see in a trust administration, for example. Finally, the last hurdle to keep in mind is kind of a lack of control. In the court probate cases, we have to work at the judge's orders, so nothing can really kind of be done until we get judge's orders signing off on things getting done. Property can be sold, but everything done with assets needs to be accounted for, presented to the court. The court provides oversight, which is an advantage to the process, but if there are any special assets or something particular that needs to get done outside of generally selling assets, well, now we need the court to give us an order to allow us to do that, And then we also need to file notices with everybody interested to make sure that no one in that sense is going to argue against or challenge that action. On top of that, if there is no will, we're now governed by the laws of intestate succession. That means we're going to look at the California Probate Code to determine who is a beneficiary here. It's all going to be set in the code. There's no way to determine who should be a beneficiary or maybe who morally might be better entitled to receive something. The probate code says distribute to this person, this person, and this person. So that's what the court is going to order. And that might also crop up if there is a provision in the will, such as the distribution or anything, that gets subsequently invalidated. Now the section of the will is invalidated or the entire will, and now we're under that intestate succession and we're stuck with what the probate code says to do. So that does provide some oversight into the process, but it does not provide a lot of flexibility when it comes to actually managing the estate and getting the assets down to the intended beneficiaries. Thus, to kind of wrap all this up, again, our office does recommend our clients typically avoid the formal probate process for their estates by properly funding a living trust. But if you are involved in an estate that does look like it needs to go through probate, there are some hurdles or disadvantages that you should be aware of, so you keep in mind going through that process so you're not surprised by anything. Firstly, we need to worry about is the fees of the situation. Like I mentioned before, about $1,500 or so is what you can expect for just random fees alone. Then on top of that, you have the attorney fees, which are set by the probate code, and the fees for the manager. They get the same fees as the attorney. Next, we need to worry about the court's timeline. We have to work on the court's calendar, meaning we're stuck on whatever their availability is. Next, public proceedings. These instances or these cases are subject to public proceedings because they are in a court system. That also means the filings that get done are also open to inspection, meaning if I put a distribution down in my will, that is now open to inspection for people to look at and scrutinize. Finally, we do need to worry about the lack of control over the situation. While the court is going to supervise everything, they are going to be following the rigid probate code rules, meaning that there is not a lot of flexibility to work around. If the code says give it to this person, then the code says give it to that person, and you have to do it. You're stuck. That is in contrast to a revocable living trust where you can do conditions or even non-standard distributions through your trust. But a probate court proceeding, you are kind of subject to losing some of that control if there is either no will or what if the will becomes ultimately invalidated. So if you do think an estate needs to go through probate, firstly, you can call our office and we can let you know if you are going to be subject to it. And then we can also discuss what you need to look out for if you are involved in that process. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.